Good evening, everyone. Welcome to another Wednesday webinar with the Property Law Alliance, and welcome Solna and Bruno.
Hi, Marley.
How are you guys doing?
Yeah, I'm good. And you guys?
Good, very good, thank you.
Yes. All right, we don't have a lot of questions to discuss this evening, but what I want to discuss first is lease agreements. So we have a scenario of a tenant which agreed to certain terms during lockdown of a lease agreement, and he took occupation, but they couldn't sign the lease agreement. And now he's not paying his rental. And he says, well, I never signed a lease agreement. What is the requirements of a lease agreement if the tenant already took occupation, agreed to the terms, but the agreement itself was never signed? Solna, do you maybe want to take this one first?
Oh, thanks, Marilee. Yes, I think actually that's something that happened quite a few times, not just during lockdown. It happens often that, for instance, the scenario would be something like the landlord or the agent on behalf of the landlord sends a written lease agreement to a tenant, and he is happy with the lease agreement, and somewhere along the line, they just don't get around to signing the lease agreement, or even the parties agree verbally and they never get around to actually even drafting a written lease agreement. So it's very important to realize that there is no legal requirement for a lease agreement to be in writing. A lease agreement can be in writing, it can be verbal, and it can even be a tacit lease agreement. So a tacit agreement would be something where somebody takes occupation of a premises, pays rent, and this very often happens where, for instance, somebody moves in with someone else. The person that was initially the tenant or the initial occupant vacates or passes away or whatever happens, and the person that remains in occupation of the premises just continues to pay rent. The landlord accepts the rental, and that would be a tacit agreement. So there isn't even a verbal agreement because the parties never even had a conversation about this. It just kind of happened. And even the it just kind of happened agreements, which is also tacit agreements, those are also legally enforceable agreements. So it's very important to know this, because I very often, and Bruno, I'm guessing you get exactly the same thing, where a client would call or somebody inquire around a property, and they will always, around an eviction, and they will say, but there is no lease agreement. Yeah. And then when you start asking the question, you need to break the news, but there is actually a lease agreement. It could be on a month-to-month basis after the original agreement expired and the person remained in occupation, or it's a verbal agreement. Those agreements are still legally enforceable. Now, Marilee, the only thing that could potentially happen is if your lease agreement states something different, for instance, the fines, and this is the position in the TPN leaseback, so I know there's a lot of users on that. The TPN leaseback lease specifically states that signature date means when the last party signs. Now, what happens if the last party doesn't sign? Well, that's actually quite convenient, because Regulation 4 of the unfair regulation specifically says that should a tenant not sign a lease agreement but takes occupation and starts paying rent, in that case, the agreement is deemed to have been signed and delivered to the landlord in any event. So that's a long story now on an actual written agreement that was never signed. The Rental Housing Act regulation specifically caters for that. So then the agreement is enforceable. The exact same agreement that was initially sent to the tenant, the terms of that agreement is then enforceable. However, if it was just a verbal agreement in that particular situation, you won't even have to worry about that they take occupation or whatever the case might be. A verbal agreement is equally enforceable. I really advise people to stay very far away from verbal agreements, and the only reason for that is to prove the terms of a verbal agreement means that you will have to go to court on trial, not on application, to lead oral evidence so the parties can be cross-examined to find out what the terms of the agreement is. Now, why this is a problem is on application, even if the matter is opposed, we can be in court in about, depending on the court, and let's pretend the whole lockdown didn't change the way we get court dates, but even on an opposed matter, we can be in court in about 4 to 6 months, where if you're on trial, even in the magistrate courts with relatively open roles, you will only be in court in about a year, if you are lucky, more likely a year and a half to 2 years from now.
Okay, perfect. Thank you, Silna. Bruno, do you maybe have anything to add to that?
So maybe just to speak as to how often this actually happens. I'm dealing with 2 cases at the moment on this very issue, and the difficulty. So for starters, what Silna said about verbal lease agreements, I cannot agree with more. Or any agreement for that matter. I mean, just get it in writing, even if it's a WhatsApp, an email. It's really not that difficult. I mean, even us as attorneys, we're trained during our articles to write down our telephone calls and even email them back out, just to say, listen, here's minutes of what we discussed. The reason for this, and this is actually proven, now this isn't about law, it's more about psychology, but I was even reading a book the other day where they tested memory over a period of time, and a person's memory, what they recollect today, and they write it down. These were test subjects, and they asked 1 year down the line, 2 years down the line, and a couple of years, and what they realized is the persons believed things to be true, but when they compared it with the initial notes, they were far from the truth. And the human brain does tend to do that naturally. It's not even a deterioration of the brain. It is just a natural thing. We keep important information, and we learn to believe things happen one way as opposed to another way. So verbal lease agreements, totally agree. Insofar as tacit lease agreements are concerned, always be proactive as a landlord. So I've got an instance in a building in the CBD where the lease agreement was signed in 1998. So it's 22 years later. We actually don't really even understand who's staying there, but as far as we can tell, it's the children of the tenant who passed away. So now it's a question of actually proving that you tacitly, they stayed on the property, they continue to pay rent. Were there certain escalations in place? It's just this, it's unnecessary. And I mean, for us, it's not a difficult case because the reality is they are in breach whether you like it or not. So it's, you know, for us, it's relatively simple to make our case. But you don't want that, especially from a rental collection perspective. We are more worried about the eviction and getting the people out. But if you're actually trying to prove your rental collection, it's a nightmare. It's so difficult. It's so difficult to get right with it. So just manage your leases properly. Make sure that your estate agents do the same. Always keep up-to-date leases. But basically, just reiterating what Silna said, any agreement is enforceable. Only certain agreements are excluded, and they're very specific. So there, your attorney will tell you, listen, selling of immovable property has to be in writing. Things like wills, for example, have to be in writing. Suretyship have to be in writing. Lease agreements don't necessarily have to be in writing, but they should.
Yeah, no, I completely agree. All right, thank you for that. Then we did have a comment on our Facebook page about land development and rezoning. I don't know if we want to quickly just discuss that, Bruno, if you want to.
So it's actually something, yeah, it's so just very quickly, what most of our clients do need to understand is the actual development and zoning process, although very interlinked with the law itself, is not actually a legal function for the most part. So what we tend to find is town planners, for example, remember the legislation and the regulations that deal with zoning are quite intensive. There's frameworks that are put into place. They're constantly changing. So people, it's almost a specialization in itself. So what I very often say is accountants, auditors, chartered accountants, in my mind, are lawyers with numbers. If I had to say the same about town planners, it's exactly that. It is a specialization because if I phone my town planner up now and say, I've got a client that wants to do this, and I give them the area, immediately off the bat, they know exactly what applies in that area, what we should be looking for, what the specific requirements are, differences between Mohale City and Ekurhuleni. They know this off the bat. Us as lawyers, we don't necessarily do that on a consistent basis. So it's not really a conversation for us to have, especially on a platform like this, where we do tend to elaborate a lot from experience. That is a question where it's better off probably bringing a town planner on board and saying, what are the questions? Let's actually get these answers to people. If it's about consent use or getting a certain amount of people onto a property as a multi-let, let's actually explore it, ask the question, and we'll source the answers. That's very easy for us to do.
Okay, perfect. Thank you for clarifying that. Silna, do you have anything to add?
Yeah, I think the only thing I agree with Bruno 100%, and I actually get the question quite often, like, we need to do rezoning, can you assist? And then I always say, oh, no, wrong people, wrong crowd. But I think what's the only thing I would like to add is conveyances, obviously, as much as we don't actually do the actual rezoning process and the whole thing, or the development and the town plan, we have relationships with the right people. So we have relationships with town planners, with builders, with architects, with civil engineers, with all those kind of things. So an attorney is very often the conveyance part of a development. Very often is seen as almost a project manager, if I can say that. There is always an actual project manager, but the initial process, the attorneys usually, we're the weird ones. We might not be fantastic at mathematics, but we are brilliant at building relationships and networks. So we usually have a pretty big crowd that we can pull in when it comes to a development. So you can still go to your conveyancer to get the whole thing together, but we don't actually do the actual rezoning.
Yeah, exactly.
All right, thank you for that. I think it's very important to clarify that. And then installment sale agreements. I just want us to have a discussion about that again. I know we have discussed it in previous webinars, but I know you said specifically that an installment sale agreement is limited to 5 years. Now, let's say a person are busy with negotiations and want to conclude an installment sale agreement, but for 20 years. Is that possible at all? I think if we maybe can just refresh the viewers' minds regarding installment sale agreements and then take it from there. So now, do you maybe want to get started?
Yes, this is actually a very nice conversation. Bruno and I have had this conversation. Bruno, I think this is basically a weekly conversation we have. Apart from the weekly conversation we have where people watch us have conversations. But we've had this conversation last week again, because in terms of the Alienation of Land Act, it says that in certain situations, the time period over which an installment agreement may run is limited to 5 years. So minimum, a few requirements like minimum of 2 installments, minimum of a time period of 13 months, and then it's immediately read as a maximum of 5 years. But the truth is, and Bruno, I'm going to leave it to you to dive into the actual detail around it, but the long and the short of it is that is only in relation to property that doesn't have its own title deed. Okay, so let's quickly talk about that. And then, Bruno, I'm going to throw the ball straight to you, hot potato it. So the thing is, let's think about this. How many pieces of land in South Africa doesn't have its own title deed? So Bruno and I have discussed this last week, and one of the things is, if you are doing town planning, so apparently the theme for tonight is town planning and development. So if you are doing town planning, or you've subdivided a piece of land, or whatever the case might be, those individual pieces of land, until the process is complete and the title deeds are issued on the individual pieces of land, those pieces of land would form part of that requirement of the Alienation of Land Act that says that it may not exceed a period of 5 years. So what I'm saying is that is only in extremely limited circumstances where your installment sale agreement may not exceed a time period of 5 years. The rest of the time, you're not limited to 5 years, and it could in fact be a 20-year lease, 20-year. Whoa, this is how you know you're the rental lawyer, hey? Lease agreement, installment sale agreement. But Bruno, I think you would elaborate on that much better. So, hot potato to you, sir.
Yeah, so I think the last time we were on the phone discussing this for about 40 minutes. So just to give context, it is a bit of a strange topic. The reason being that if you read some of the articles, you do some of the research, very off the bat layperson research, and you simply Google an answer, you see that 5-year restriction consistently, right? And then I actually got it got brought to my attention because there's certain companies that offer services where if you do want to buy a property but you don't have great affordability, you can approach them, they'll buy it on your behalf, and then they'll sell it back to you in installments. And there's a couple of companies that do this. It's a really novel concept. Obviously, it comes at a cost, so it's not necessarily for the investor side of the market. You know, basically most of the people that watch us are estate agents and investors. It's not really for you guys, but the reality is they still end up negotiating these agreements for 10, 20 years. So, you know, seeing this contrast, we started exploring and trying to figure out, but hold on, wait, how is it done? And there's a couple of ways of doing it that I came up with that don't involve installment sale agreements. But the reality is when you read the Act pretty much says that there's a 5-year cap when it comes to these agreements on land not containing its own title deed, exactly what Silna spoke about. I can honestly say in my experience, I've rarely ever found land like this. From our discussions, from our discussions and discussions with other people, it's land, for example, that under a township that hasn't been proclaimed yet, but you're very seldom selling this land to begin with, let alone on installments. So it's not something that I've ever come across. But if you read the actual wording of the Act, it's restricted to that, meaning that, in our opinion, you can enter into an installment sale agreement for longer than 5 years. But now let's apply this knowledge and see what we can do with it. Certain companies are getting away with it. Great. So it means it can be done. Some people are doing it. I highly doubt that the deeds office will in themselves reject an installment sale agreement. Maybe they will, maybe they won't, not sure whether they read the specific terms or whether they see installment sale and they simply register it. So that's something that we'd actually love to test out to see exactly where the deeds office sits with that. Bear in mind that most installment sale agreements are limited to 5 years, not because of the legislation, but because of feasibility. Many people don't want to enter into installment sale agreements longer than that. So a lot of our experience has always been installment sale agreements at 5. I have been able to register ones that are longer, but it's possibly because no one's noticed it. So where does the problem come in? What we experienced recently is the bank. So if a bank has a bond over the property and we go to them with an installment sale agreement and ask them, great, can we have your consent to please register this against the property, which is in addition to your mortgage bond? So we're required to ask their permission. And instead of simply saying yay or nay, they went, hold on, but it's more than 5 years, we don't like it. We confronted them and asked, please explain, where do you, what's your issue? Where does it arise from? And their answer was to point to the specific section that dealt with land that's not subject to a title deed. And no matter how much you argued, it didn't matter because they have internal policies that are a bit of a mission to get around. So, if you want the deal done, you get the deal done. So we made a plan. In fact, what we landed up doing is we created an addendum that extended it in the event of something happening. So it's still not, I'm not totally comfortable with that, but we did it because that was the requirement of the client. And in this addendum, if at the end of 5 years, we still needed more time, upon the happening of a certain event and a certain notice given by the seller, the contract would extend for another 5 years, and we got our 10. But I'm at the point now from an application perspective, I'm looking at two things basically. If you're going to negotiate, if you want to play it safe, try to keep it for 5 years. We all know that works. If your deal only works at over 5 years, do it. let's see if it can get done, if we can register it. If there are any issues, we'd also love to actually take on a client and see if we have a case that we can start working on, something that we can take to court. And that court perspective is something that the case would have to be 100% perfect. There'd have to be no rush on your deal. The person would have to have complete patience, because this could take really long. But just to kind of get clarity, we'd actually love to see if anyone does approach us willing to actually take it to court. But yeah, until then, let's just try our luck, see if you can get a 10-year across the line. Otherwise, stick to your 5 years. We know that works. And if we can get it done.
Perfect. Solna, do you have anything else to say about installment sale agreements? Any last thoughts?
No, I think the only last thought I have is exactly what Bruno just said. That was part of our 40-minute discussion last week, and we both said it would be brilliant if we can get a test case where a client is not in a hurry. We can take it to court and we can get some legal clarity on that, because the truth is, legal certainty is more important than anything else, because if you know, even if you take something to court and the answer is no, at least then we know the answer is no. But interpretation of legislation has to be done in a very specific way, and very often you need the courts to direct the interpretation just to give legal certainty. So if there is somebody out there specifically looking to do a test case like that, Bruno and I already said we are more than happy to join forces to bring an application like that and give time and brainstorm. And so if you have a case like that, definitely be in contact with us. We will team effort. The first one ever, we bring an application in the name of something completely different, like the Property Law Alliance. Like to see the court face on that one. that in its own is a bit of a test case, Bruno. But yeah, that would be brilliant if we can get some legal clarity on that. The only way to do that would be to take a matter to court and get the court to interpret. That would obviously mean that you will have to go to a high court to create some precedent. So you don't just get an answer from a lower court and then it's not an answer for everybody else.
There's no value, yeah, absolutely.
Exactly.
Yeah.
Okay, perfect. I think that is about the time that we have this evening. Do you have any last thoughts, Bruno, maybe?
No, I'm good.
Are you good?
It was a long day.
Yes, a long week already.
I think it's more the year. I think it's been a very, very long year. But it's already halfway through September. I can't believe that. Time flies when you're having fun.
In our famous words of last week, it's been a COVID-y week.
Yeah, definitely. All right, but thank you so much, Solna and Bruno, and thank you for all our viewers. And then have a lovely evening. And then we'll see you next week as well.
Brilliant. Thank you. Bye-bye.
Bye.